Academic Affairs here at the law school. And it is my pleasure on behalf of the law school to welcome you to this very timely and important lecture by Professor Fatma Marouf on LGBT immigration equality post-Obergefell, or Post-Obergefell? I guess it's a question, sorry. So this event is co-hosted by Lambda, the National Lawyers Guild, the International Law Society, and the American Constitution Society, our student organizations here. I'd like to thank all of those student groups for their hard work organizing this event. And of course, Nancy Pratt-Cantor, who is always behind the scenes as well, assisting with all of our lectures and events. And thanks to you all for being here. I am going to turn it over now to Professor Michael Sharon, who will introduce our speaker.
Thank you, Dean. I'm an immigration attorney. I have represented numerous married, gay, and lesbian couples in obtaining lawful permanent residency. And I'm proud to be part of the law office, Sharon and Kalnoki, that was the first law firm in Ohio to have a gay couple adjusted as permanent residents. In addition, I'm an adjunct professor here at CASE, and every other year I teach a course in business immigration. And if you took my course last year, which I know at least one of you have, you'll be familiar with the term an EB11. And I'm not going to call on you to ask you to explain, but an EB11 is an individual extraordinary ability. And that's like at the cream of the crop at the very top of the heap. And in order to get that approved, you have to have some pretty incredible credentials. Well, I can tell you right now that our speaker today, Fatma Marouf, would be an EB11. But you had never thought of it that way. Anyway, Fatma Marouf is an associate professor and co-director of the Immigration Clinic at the University of Nevada, Las Vegas. Her expertise is in immigration and international human rights law. She has authored a large number of scholarly articles, most recently addressing the intersection of constitutional and immigration law, including the rights of mentally incompetent non-citizens, the exclusion of dreamers from the Affordable Care Act, and the use of restraints in removal proceedings. In her spare time, if she has any, she conducts empirical research in the adjudication of immigration appeals by federal appellate courts. Appropriately for her lecture today, she has represented numerous LGBT individuals applying for asylum, legal permanent residency, and visas for victims of human trafficking and other crimes. Professor Marouf graduated from Yale and Harvard Law School, both with Latin honors. She's also pursuing a master's of public health at Harvard. I don't know how you can do that too. Online. All right, very good. Prior to entering academia, Professor Marouf practiced immigration law from 2005 to 2010, handling all types of cases, including asylum, deportation defense, family and business immigration. She also worked as a staff attorney for California Rural Legal Assistance, representing low-income individuals in the areas of housing rights, education rights, and public benefits. She has been a judicial law clerk at the U.S. District Court in Central District of California for the Honorable Consuelo B. Marshall. Without further ado, though there's probably more ado I could go through, I'd like to introduce Professor Marouf.
Thank you for that introduction. That's very kind. I'm just curious here, how many of you are law students? Okay, and how many are attorneys? And of the attorneys, how many are immigration attorneys? Okay, great. So I will keep this at a non-overly complicated level, but to give you more of a broad overview of how immigration law has responded, both pre-Obergefell and post-Obergefell, sort of what's going on. And I'm not going to limit it just to marriage issues, but to sort of LGBT issues in immigration more generally. Can you hear me if I don't use this mic? No. No?
Oh, it's webcast.
Oh, so. I will use the mic. Okay. All right. Ooh. That's perfect for the webcast. Okay. There it goes.
This is all looking great on the webcast.
Yeah. Feel free to start it now. Okay. All right, so the Immigration and Nationality Act itself does not define marriage or a spouse in terms of the gender or sex of the spouses. So there was nothing in the INA itself that restricted same-sex couples from petitioning for each other before Obergefell. The restriction came from the Defense of Marriage Act, DOMA. And DOMA had Section 3 that specifically defined spouses within a marriage as being a man and a woman. And so that's where the restriction came from. And since that's a federal law, it was binding on all federal agencies, including the immigration agencies. So this prevented immigration officials from allowing same-sex couples to petition for each other or to even call a spouse, right, somebody of the same sex, even when they were legally married. So one thing to note is before any legal changes around same-sex marriage, transgender couples were recognized, or I'll be more specific, a couple where one person, right, had transitioned, and so the couple was an opposite-sex couple with one biologic male and one male to female transgender individual. That was considered an opposite-sex couple and was recognized with no problem, or should have been recognized with no problem, before any changes around same-sex marriage, because they were treated as an opposite-sex couple. Now, the issue was whether the state recognized the transgender individual's new sex. So did they recognize their post-transition sex or not? And I was just telling Michael over here that, you know, one of these cases I did, even though the person had transitioned and the state of California had issued it was a U.S. citizen who was a male to female transgender person and had gotten a driver's license in California with the gender as female, had some biological interventions, hormones, breast surgery, but not a full gender reassignment surgery, and was married to a man, and we did their case as an opposite sex couple case, and the the USCIS at the basic filing level did not treat my client as a female, did not recognize that as an opposite sex marriage, and just denied it, saying they were ineligible. And the reason was because she couldn't get a new birth certificate that showed her gender as being female. She had been born in the state of Indiana, which required gender reassignment surgery that she didn't want to have in order to treat her as a female. So there were still obstacles. I don't want it to seem like this was an easy road. Now, that decision came down around 2010, and I appealed it, right? I argued that they were married as an opposite-sex couple, and unfortunately the marriage certificate didn't help me because they got married, or it did help me, depending, but they got married in California during that window of time where gay marriages were temporarily taking place, and the California marriage certificates did not identify the sex of either party. So the marriage certificate didn't tell us if this was an opposite-sex or a same-sex marriage. But we did have a California driver's license and her own surgeon's letter saying that she should be treated as a female, or considered a female. So that case was actually remanded on appeal without any explanation. The government just sent it back and it was approved with no legal reasoning and no explanation. So I was kind of left guessing, like, are they approving a same-sex marriage because they didn't treat this as an opposite-sex marriage? Or are they just implicitly recognizing they made a mistake and approving it as an opposite-sex marriage? It was very unclear, and by that time, my clients had already moved to Australia, where one of the partners was from, and they never ended up pursuing their status here. But that was a case in that sort of transition period where we didn't know exactly what was going on. Now, the main case that allowed couples to petition for each other, same-sex couples, was not Obergefell, it was Windsor. Because Windsor was the case decided in 2013 that struck down the Defense of Marriage Act as unconstitutional. And it struck down that definition of a spouse under federal law as being between a man and a woman. So post-Windsor, President Obama basically told all the federal agencies, you need to implement this widely throughout. And that included immigration agencies. So as soon as Windsor was decided, U.S. Citizenship and Immigration Services, USCIS, started approving and, adjudicating same-sex marriages just the same as they would opposite-sex marriages. And this change wasn't just limited to marriage. I'm going to talk about some of the effects it had. So Windsor was decided under the Due Process Clause, right? And Justice Kennedy basically reasoned that, if the state is going to recognize this marriage, then who are the feds to say it's not a marriage, right? So this is President Obama with Edith Windsor. directing federal agencies to basically go to it. So the consequences for immigration are multifaceted, okay? So one thing, the most obvious thing, right, is that a married couple, where one is a U.S. citizen and one is a non-citizen, right, the U.S. citizen can petition for that same-sex husband or wife or spouse, right, to become a legal permanent resident so they can remain here. Another thing would be that a U.S. citizen can petition before they even get married for a fiance who is of the same sex. That's not something that's available to LPRs, but it's something that is available to U.S. citizens. A third thing would be, non-citizen who is married to a U.S. citizen in a same-sex relationship, but it's an abusive relationship, right? The non-citizen could self-petition on their own now in order to become a legal permanent resident. This is something Congress allowed to happen many years ago because we didn't want abused spouses to be stuck in an abusive relationship in order to try to get their immigration status. So they allowed the immigrant spouse to self-petition, to effectively petition for themselves, as long as they can show the marriage was, entered in good faith and that they were subjected to abuse by that U.S. citizen or legal permanent resident partner. They were allowed to then on their own become legal permanent residents without the assistance of the abusive spouse. And in addition, USCIS reopened, if attorneys asked old cases to be reopened, USCIS actually went back and reopened cases that had been denied solely based on Section 3 of DOMA. So solely based on the fact that this was a same-sex couple. So in the marriage realm, we have all of these developments. But it's not just limited to the marriage realm. There's lots of different types of family-based petitions in immigration law. You can have brothers and sisters, right? Parents petitioning for children, children petitioning for parents, right? And the definition of a spouse helps define all of these family relationships. So by redefining a spouse, it actually had a much broader impact on all sorts of family-based immigration petitions, because now the family relationships were defined in new ways that were previously unrecognized. Then completely outside of that, right, you have all sorts of different visas, work-based visas, student visas, right, asylum, T visas, where you have derivatives. Basically, the family members are included on the application. And one of those family members is usually the spouse. So now you could have your same-sex spouse included on all of those applications as well. Even though this had nothing to do with the marriage case, right, the spouse, same-sex spouse is benefiting by being a derivative on these other types of applications. And in certain areas like naturalization, there's special rules in terms of residency requirements for citizens. So, once you've been LPR for 3 years, if you're married to a U.S. citizen, you can then naturalize, which is the process of becoming a citizen. If it's not based on marriage, you would normally have to wait 5 years. So this also reduced the waiting time for naturalization for legal permanent residents in same-sex marriages. Then a whole nother area of immigration that was affected there's certain things that when people are in removal proceedings, they can apply for. And one of those things is called cancellation of removal. So a judge can actually decide that someone who's undocumented should not be deported and should be allowed to become a permanent resident in court. And these are tough cases to win, but one of the requirements is that you show exceptional or extremely unusual hardship to a U.S. citizen, spouse, parent, or child, or LPR. And so again, the definition of a spouse is critical here, because now you could show that your same-sex spouse would qualify here as the qualifying relative on the basis of which, an immigrant could get cancellation of removal. Similarly, inadmissibility waivers. So these are people often who've been convicted of some crime and need to waive that crime in order to adjust their status to an LPR or in order to get some other type of visa. And to do that, one of the ways to get that waiver is to show extreme hardship to a qualifying relative. Again, a spouse can be a qualifying relative. So the definition of a spouse has a profound impact on who is eligible for that waiver. The 3 and 10 year bars, who knows, has anyone taken immigration law? Know what those are? Yes, sir.
If you overstay for 6 months or below, you come into 3 years, or 1 6 months, 10 years.
Great, you should be in my class because people still don't know that. Okay, yes, so people who overstay, people don't realize that, right, once you're here without status, the minute you set foot outside the US, you can't just go back to a consulate and get your visa and come in, right? You trigger these bars just by having been here. So as you said, sir, once you're here like a year without status and you leave, you're barred for 10 years. Now there's, again, a waiver of these bars, and it's based on showing extreme hardship to a spouse or parent. So again, having that US citizen spouse spouse or LPR spouse is extremely important. So this is where we were in 2013. This was the map in terms of which states recognize same-sex marriage. So Windsor was helpful if you could get married, right? You still had to be married, and you could be married in any state. But at that time, not that many states allowed same-sex marriage, right? So this was the map where you can see all the black states, there were constitutional bans, right? You can see even California, you have civil unions, but not gay marriage. Only the red states, right? You see New York, Washington, et cetera, they have same-sex marriage, right? But those are very few states on the map. We see the US changing very quickly between 2013, when Windsor was decided, and 2015, when Obergefell was decided. So if we look at the map here, not the map, but at the population of LGBT immigrants at that time, there's a center at UCLA called the Williams Institute that looks specifically at researches LGBT issues, and they issued this report on LGBT immigrants in 2013. And according to their research, there are over 600,000 LGBT documented immigrants and another 267,000 undocumented at that time in 2013. Just to get a sense of what the population looked like in terms of gender, you can see it's more male than female in terms of both documented and undocumented LGBT immigrants. So especially among the undocumented, you have about 2/3 male versus 1/3 female. If you look at race, you can see Hispanics are 30% of the documented population, but of LGBTs, right? But 70% of the undocumented LGBT population. You can also see that the Asian Pacific Islander group has quite a heavy presence in both categories, 35% and 15%. If you look at age, you see young people represented quite heavily. So among the documented, you have 30% being under the age of 30, and among the undocumented, you have almost 50% being under the age of 30. So this is a more male population. Now, in terms of same-sex couples at that time, there were over 113,000 individuals in same-sex couples and about 89,000 couples, or 88,000 couples. And those couples had, thousands of children. Sometimes you have binational couples where both people, neither person is a U.S. citizen, binational couples where one person's a U.S. citizen and one person isn't often, or you can have couples where neither person is a U.S. citizen. Okay, so by May 2014, you can see the map is starting to change. We have the blue states now where same-sex marriage is legal. So you can see California, Oregon, New Mexico, right? A bunch of other states have now legalized same-sex marriage. We have a bunch of states with appeals pending. So in the yellow states, the bans were overturned, but we're still on appeal. In the orange states, the marriage was banned, but civil unions were being recognized. And in the red states, marriage was still banned. So by November 2014, the circuit split had emerged, which is the circuit split that was at issue when Obergefell was decided. So you had the 4th, the 7th, the 9th, and the 10th circuits all holding that the bans on same-sex marriage were unconstitutional. And then you had the 6th circuit, where we are now, on the other side, right? Which said it was bound by this old 1971 Minnesota Supreme Court case in Baker saying that it couldn't recognize same-sex marriage. So it found it constitutional. So this is the issue that goes up to the Supreme Court in Obergefell. And so right before Obergefell was decided, you had 36 states recognizing same-sex marriage, as well as DC, Guam, U.S. Virgin Islands was about to recognize, Puerto Rico had announced it would recognize, Mariana Islands, so these are U.S. territories also recognizing that they would recognize same-sex marriage. So, and this is what the map looks like before Obergefell. So you can see it's dramatically changed from 2013 when we had all those black states, right? Remember this was, I guess it was a while back. All those black states, right, were banning it. And by 2015, pre-Obergefell, you have the vast majority of states actually now recognizing it. So that was a sweeping change in the U.S. over those 2 years. So as I'm sure you all know, Obergefell was a close decision. It was a 5-4 decision. It held that, the bans on same-sex marriage were unconstitutional under both due process and under equal protection grounds. And, there were many couples involved in that case, and Obergefell was just the lead plaintiff pictured here. He was here from Ohio here. So what are the consequences of Obergefell's holding, right? Well, same-sex marriages have to be recognized throughout the U.S., so this makes it easy for couples to get married everywhere, right? They don't have to travel large distances to get married. And then if they are married and they're traveling around within the U.S., there's no question that their marriage is going to be recognized just because they happen to be in a different state that doesn't recognize it, right? Because it has to be recognized everywhere. So in terms of immigration benefits, they have all of the same benefits as opposite-sex couples would have. But this does not mean that all is well in the land of LGBT immigration, and that's why I put a question mark in the title, right? There are huge problems facing LGBT immigrants, and marriage is, I think, one of the more minor ones. I mean, this is great for a lot of people, but there are some real serious human rights problems that need to be addressed. And I'm going to talk a little bit about those as well. So I'm going to talk a little bit about asylum, and I'm going to talk about immigration detention, which is an issue I've been working on a lot recently, and a report that I've been preparing for the UN on specifically detention of LGBT immigrants in the US. So what are the legal challenges that we see come up frequently in LGBT asylum cases? So asylum is a form of relief. It's basically the same as refugee status. You apply for it once you arrive in the US if you fear persecution in your home country or you've experienced persecution in the past. And it can be only for certain reasons. And courts have recognized sexual orientation or gender identity as one of the reasons that can be the basis for an asylum application. Now, some of the barriers, this is not an exhaustive list, but some of the common barriers or challenges that LGBT asylum seekers face is what we call the 1-year deadline. So to get asylum in the US, you have to apply within 1 year of arriving in the country with certain exceptions. And the US made this up. It's not in the Refugee Convention. Most other countries don't have a 1-year deadline, but we do. And so for a lot of people, and particularly transgender people who've come here, they don't usually apply for right away for many reasons, right? One is that they've usually experienced severe trauma. They're just trying to adapt to being here. Often they're focused on transitioning, getting the support they need, getting the medical care they need. They're usually extremely poor. Many of them have never encountered an attorney. They had never even heard of asylum, right? So by the time they find out about asylum and find an attorney who can help them, it's been often years. I've had clients who've been here 15, 20 years before they're finally aware of asylum. So the 1-year deadline is a big problem. Now, there are exceptions to it that include changes in your personal circumstances or changes in country conditions. So for somebody to transition, one of the arguments we often make is that transition is a change circumstance that, would toll the 1-year bar until the time that change took place. Often people were already taking hormones on the black market or what have you, so it's not like they went from zero to transitioning overnight, but often when they get to the US, they get a much higher level of care that, things are expedited in terms of their transition, and where they may have presented sometimes as male and sometimes as female before, now they're primarily presenting as one or the other. So a lot of the harm that people experience, including being beaten, being raped, it can be at the hands of the government, police in particular, but it can also be often by other private individuals. And for asylum, if the harm isn't by the government, you have to show that the government is unwilling or unable to protect you. So that can be a challenge in some countries. This is something we can usually overcome. There's really good human rights reports and things out there showing that governments are not very good at protecting LGBT people. We get a lot of applicants, particularly from Central America, and the police are often perpetrating the violence far from protecting people from it. There was a very recent decision in the Ninth Circuit about reporting to the police. It was a Mexican transgender case. And the Ninth Circuit had been pretty lenient on this in terms of not having to report, right, in order to show that the government is unable or unwilling to protect you. The failure to report wasn't a problem if you could show it was futile to report or that reporting might itself lead to retaliation and subject you to further abuse. There was good case law, and there still is good case law. But this was a case from Mexico where the person hadn't really produced enough evidence of why they didn't report. And for that reason, the case was denied, and the Ninth Circuit affirmed the denial. And so that seemed to set sort of a higher bar, at least among immigration lawyers. We're sort of aware of that now and paying particular attention to introducing all that evidence to make sure that we can show why reporting would have been futile or subjected the person to further abuse. Another issue is that conditions are getting better for LGBT people in a lot of countries, and this is good, for many reasons. But for asylum cases, it's not so good, right? So you need to always stay on top of how country conditions are changing, and in particular Mexico, where we get a lot of clients from. A lot of, it's the #1 immigrant population in the U.S. There's improving situation for lesbian and gay individuals in particular. Not as good for transgender, but the gay and lesbian cases are getting harder and harder to win from Mexico in terms of asylum. Transgender cases still do pretty well. So in addition to those legal challenges, there's a number of practical challenges. And probably the foremost practical challenge for all immigrants in removal proceedings, not just LGBT immigrants, is there's no right to counsel, right? So about half the people are unrepresented. And among the detained population, you have 90% of people being unrepresented, often housed in remote parts of the country. So if you go to South Texas, you have massive detention centers with thousands and thousands of people hundreds of miles away from urban centers. So what attorney is gonna drive there to go see them, right? You can't call them in the detention center. They can call you, but you can't call them. You have to drive there or write to them. That makes it very hard, right, to practice law. The detained docket also moves very quickly. They call it the rocket docket. They're calling, a case every few seconds. They have group hearings with, detainees all in a row in the same hearing, being read their rights, pleading, often taking voluntary departure or taking deportation orders. So attorneys don't usually want to move that fast where they don't have time to properly prepare an application and stuff. And these people, because they're detained, they're not working, they don't have money to hire an attorney. So that's why you have over 90% of people in some of these Texas detention centers unrepresented. So asylum is a legally complex area of law. I think some of you might be taking asylum here. It's an area where lawyers can spend a lot of time. You build your whole career on it. And it's very, very hard for pro se individuals to really master on their own and to understand the in and out of it. Other things to win an asylum case, you could theoretically win on your testimony alone, but it's very hard. You want to get corroborating evidence. That's hard to do without an attorney's help, especially if you're detained. Getting experts can make the difference between winning or losing a case. Country conditions experts, medical experts, psychological experts. We put these on regularly when you prepare a case well in order to show that the harm you've experienced rises to the level of persecution, in order to show that there is a well-founded fear of persecution if you're sent back. Video hearings have become very, very common for detained individuals. So now the detainee isn't even in the same location as the judge hearing their case. So you can imagine, in particular for transgender cases, where how you appear is an important part of your case, and you can't even present yourself to the judge. And you're testifying from a room with other detainees where you're probably not comfortable presenting yourself the way you really look, right? Most transgender people who are housed, like let's say you're a transgender woman and you're being housed with men, you're probably not looking the way you would normally look, right? Just to protect yourself. And then you're having to appear by video in front of a judge in that way, and the judge is gonna be skeptical that you're even transgender. And we've definitely had that happen. And then we have judges and trial attorneys who are still very ignorant about gender identity. They understand sexual orientation a little bit better, but they don't always understand the difference between sexual orientation and gender identity, or they don't understand gender identity at all. And that's something we still have a lot of education to do with these judges and attorneys. So I'm going to turn to talk about immigration detention a bit. So we detain by tenfold, we detain about 440,000 people a year. Now, if you look at Europe, you see Germany is the second highest after the US country in terms of asylum applications it receives. It detains 1/10 or less of 1/10 of what we detain, okay? So you're looking at European countries that detain at most 30, 40,000. I think Germany has actually scaled down to under 10,000. Australia has scaled down to a few thousand. we detain 440,000. So first of all, we have we're massively over detaining people. I mean, it is a huge, it's the biggest area of incarceration in the US. And remember, this is not a criminal procedure. This is an administrative civil procedure. But we detain people in exactly the same places we would detain criminals. So ICE has its own detention centers, but about 60% of the detention centers are basically subcontracted jails, right? So it is actually a jail people are housed in. They're wearing jumpsuits. They're in shackles in court. And to any outside person, it would appear that this is criminal detention, except we just call it civil immigration detention. Yes, sir?
Where are these located?
They're all over the U.S. There's over 250 detention centers. They're spread throughout the country, but they tend to be clustered in certain locations. So California, Texas, Florida have some of the highest numbers of detainees. I think Texas has about a quarter of the ones in the whole country. And they're private. So some of them are privatized. So we have Corrections Corporation of America, CCA, running them as for-profit facilities, as we have with other jails and prisons. Okay, so immigration detention is bad for everyone. I don't mean to say it's only bad for LGBT people by any means, but LGBT people are at particular risk of certain types of harm in detention. And abuse, physical and sexual abuse, sexual violence in particular, they're at far higher risk than any other group, especially transgender women. I'm going to talk about each of these areas: access to medical care, housing, solitary confinement, which continues to be used, and the Department of Homeland Security, ICE's new risk classification assessment, which is a new tool they use to determine who should be detained, who should be released, and what classification of sort of what degree of detention should be used on the people who are detained. So there's lots of different reports that have been written on the risk of sexual assault in detention, in immigration detention. So the Center for American Progress did a FOIA request, got a lot of records, and has accounted for over 200 incidents of abuse, not all of them sexual assaults, but specifically against LGBT detainees in the last several years. These are, because ICE doesn't necessarily record the gender identity or sexual orientation of the detainee in these reports, these are only the ones where the description of the incident specifically mentioned the person's sexual orientation or gender identity. So it could actually be a much higher number than this. According to the Government Accountability Office, which monitors government agencies, it's a congressional office that looks at how different issues are handled, including sort of sexual violence in prisons and in immigration detention. So this report on immigration detention found that 1 out of 5 substantiated cases of sexual assault involved a transgender detainee. So 20%, when there are only 1 out of every 500 detainees are transgender. So transgender individuals are head and shoulders the highest above anybody else as the group most at risk of violence in detention. In fact, 40% of transgender women in prisons, this is not just immigration, this is all prisons, and 27% of trans women in jails, any jail, have reported being sexually assaulted within the last year. And that is 10 times higher than the general inmate population. So even though these numbers aren't specific to immigration jails, at least the last number isn't, remember that immigration detentions are just subcontracted jails. So you would actually think that the number is probably similar to that 27% that you see up here. So what about access to medical care? Again, bad for everybody in immigration detention, but there are certain issues specific to the LGBT population. So one is concern around access to HIV medications or sexually transmitted infections in general, but HIV in particular. There have been ongoing issues in getting timely access to HIV meds. People are transferred around the country a lot from one immigration detention center to another, and one of the problems is their meds aren't transferred with them. So by the time they get to a new detention center, they're having to be reevaluated, meds re-prescribed. What's happening is there's gaps, long gaps in treatment, and then people become immune to whatever they're getting. So those drugs don't work for them anymore. Also, they're just getting sick during those gaps, right? And LGBT people tend to have higher rates because of different things, including often they've been sexually assaulted, especially if they're asylum seekers, or they've had to engage in sex work, especially transgender individuals who have been discriminated against in all other forms of employment. In terms of access to transition-related care, so for transgender individuals, the policy of ICE is that if you were on, say, hormones or whatever therapy before coming in particular hormone therapy, they will continue it in the detention center, but they won't start it if you weren't on it before. But again, there's problems about people actually getting their hormone therapy in detention. There's very high risks of mental illness among this population, in particular depression, anxiety disorders, post-traumatic stress disorder, because of the past persecution, which is often, exacerbated by detention itself. So people who were beaten or raped by the police and subjected to arbitrary detentions in their home countries are then coming to the US, being put in detention, and that re-traumatizes them and exacerbates whatever pre-existing mental illnesses they may have had. Suicide is the #1 cause of death in immigration detention, and often you have LGBT people disproportionately committing suicide, especially transgender people. We've also had we've seen LGBT immigrants with just basic things like hepatitis C, needing insulin, needing all these different drugs that anybody might need, right, not getting them. So that's just sort of the baseline. And really poor access to mental health care. And even we've seen incidents of retaliation when people ask for medical treatment. So then they'll be put in solitary confinement for having asked for the treatment that they were denied. Housing continues to be a big issue for the transgender population and also gay men. And so recently, I think this slide should come first. So in April 2012, ICE actually created a separate, they call it a GBT pod, a gay, bisexual, transgender pod within the Santa Ana jail, which is the jail that's subcontracted by ICE in Santa Ana, California. So this is near LA. So they created a special housing unit. There's two units. One is for gay and bisexual men, and one is for trans women. And they created this so that they would have sort of a safer place to be housed. So when GBT people are detained anywhere around the country, they're supposed to be asked if they would like to go to the GBT pod in Santa Ana. Now, they're not being consistently asked that, for one thing. Some of them are transferred against their desire there, right? So people are having to choose, do I go to Santa Ana, California, even though I was picked up in Texas or New Jersey or wherever, and possibly be, thousands of miles away from my community, from my support network, from my family, in order to be with other, gay, bisexual, transgender individuals? Or, right, do I choose to stay where I am and be housed probably with the general male population and be more vulnerable to abuse? These are tough decisions for people to make. The other thing is the most recent reports, and Human Rights Watch just documented, just did some interviews. It hasn't published its report yet, but I spoke with the attorney doing these, and they have found lots of abuses within the GBT pod. So similar types of problems that we see in other detention centers. The guards there are supposed to have this 8-hour training course. They haven't had it yet. They still call everybody by the wrong pronoun. They still use solitary confinement to punish people for very minor things like holding hands, like they're not allowed to touch each other. If they hold hands, they're put in solitary. If they lend somebody a pencil, they're put in solitary. So these very minor types of infractions are being disproportionately penalized. They're also held isolated in their cells. So this isn't solitary confinement. This is just locked down within their cells upwards of 20 hours a day, like 22 or 23 hours a day, locked down in their cells with just an hour or two of physical activity. So that's very bad for everybody. And same problems, accessing HIV meds, accessing transition-related care within the GBT pod, right? So on the one hand, it was great that ICE tried to do something, right, to protect this population, recognizing the risk of sexual assault. On the other hand, we see very similar abuses happening within the special unit. So another major thing ICE did just this June was to create, it issued this policy, which hasn't been adopted by a single detention center yet, but ICE has published it. It's called the Detention Facility Contract Modification for Transgender Care. Now, ICE is really hoping that Santa Ana will adopt this policy. So ICE can't make detention, ICE only operates a few detention centers itself. Everyone else it has a contract with. And unless that facility modifies its contract to adopt a new ICE policy, then that policy is not in effect. So currently this is not yet in effect, but the hope is that at least Santa Ana will adopt it. This goes through some detail about what kind of care should be provided to transgender individuals. One of the things it addresses is housing, and it lists 4 options in no particular order with no particular preference for any of these. So one option is house them consistent with their biological sex. Another option is house them according to their gender identity. A third option is put them in a protective custody unit. The only one in the country right now is the GBT pod in Santa Ana. Or, notice the 4th option, medical or administrative segregation. What does that mean? That means solitary confinement. That's nice language for solitary confinement. So just put them in the type of cell that you would use for punishment, right? Except that's going to be their housing option. That is not an okay housing option under human rights law or under any other, international standard. And you'll notice that these are just or. So it's not like first try to house them according to their gender identity, right? It's either you pick, officer. So this gives the ICE officer enormous discretion over where they're going to put somebody. If they're going to house them, if they're going to house the transgender women with men, or if they're going to house them with women, which I've never seen done, or if they're going to move them to the pod, or if they're going to put them in solitary. So the 2 things that end up happening most often are, right, being housed with the general male population or being put in solitary, unless they're one of the 30 to 40 people in the pod. Okay, so I want to talk a little bit about alternatives to detention, because this is what the UN refugee agency is called UNHCR, and there's the UN High Commissioner for Refugees. And they have, one of their campaigns is to promote alternatives to detention, especially for vulnerable populations. So they've been doing it for kids, like all the children that are detained, and now they want to focus on LGBT individuals as another vulnerable population. So I'm drafting a report for them about LGBT detention in the United States. It's going to be the first country to issue this report. Other countries are supposed to do it too, but we're going to be the first, hopefully, if I get it done. There's several different alternatives to detention that currently exist. People are released on bond. People are released under an order of recognizance. That's basically they're just released, right, on their own with no bond, no conditions. An order of supervision will impose certain conditions, like reporting to ICE every so often. Parole is, again, when somebody is just allowed in, it's complicated, I won't get into it right now, but arriving aliens, like people who show up at the border and ask for asylum, are normally subject to mandatory detention. They have to be detained. And we have other huge categories of people with certain types of crimes, even very minor crimes, that trigger mandatory detention, which means ICE must detain them, the way we currently interpret our law. And then we have something called the Intensive Supervised Release Program, or ISAP. And ISAP is what ICE considers an alternative to detention. It's the only one of these that ICE thinks of as an alternative to detention. This is not a nice program in the sense that it uses electronic monitoring. So people have to wear ankle bracelets or report through telephonic monitoring with voice recognition software. But most people are doing ankle bracelets. And these are GPS tracking devices that are attached to people's ankles. They have to charge them 3 to 4 hours a day. That means they're plugged into the wall, like their body is plugged into the wall 3 to 4 hours a day. And when you have young children or you're pregnant, right, it's very hard to have a 2-year-old toddler running around and you're charging yourself and you can't move, right? So a new thing that ICE has just started exploring in greater numbers is community-based alternatives to detention, using a case management system. So more of a social work model where people it's not just about reporting and making sure people get deported once their case is over, or if they don't show up, they get picked up or whatever. It's about actually realizing that for people to show up to court and comply with court orders, one of the things that works best is to make sure they get a lawyer, to help them try to get a lawyer, to make sure they have housing, right? To make sure that they're getting the medical care they need. So it's a more holistic approach to making sure that people have their needs met, and that helps them actually follow through with the legal process, and it actually helps them leave the country if they ultimately get ordered deported. And ICE has done this very small pilot programs with the Lutheran Immigrant Refugee Services and with the Catholics. Like they've set up small, few hundred people here or there, but nothing on a large scale. Until very recently, they just launched their first family-based, it's their community family detention program, basically. So I don't know if any of you have been following what's going on with family detention, but basically we had women and children being detained as families in these awful detention facilities in Texas that were found to be really substandard. And a federal court judge in California ordered that they be shut down as in violation of a very old injunction. And so ICE had a very limited time to either get their detention centers up to par or release people. And so one of the things it did in response to this is it created this community-based detention program. It's a pilot. It's going to be about 1,500 families. It just started recently. We don't know how it's going yet. But guess who it gave the contract to run this program? GeoCorp, which is the same private corporation that ran those awful family detention centers that were ordered to be shut down. So the same company that was holding people in substandard conditions is now running, don't ask. But there's a community advisory board, and the idea that ICE says, this is very controversial, right, that ICE chose to give them the contract. But what ICE is saying is that that they will be sort of behind the scenes, and the front line will be all social workers and community organizations. That will be the face of the program. So we'll see how that plays out. But what I'm proposing in the UNHCR paper is a similar community-based alternative to detention for LGBT people. Not similar in the sense I don't want GeoCorp running it, right? But a community-based case management focus so these people cannot be detained at all, because I actually don't think there's a safe way to detain them. And even when people get released, it's very important to keep in mind that LGBT individuals continue to struggle after release for many reasons, including, high levels of poverty, inadequate access to housing for asylum seekers in this country, or any kind of individuals here who, even if they have a work permit, right, they're often not able to get a job right away. Many of them don't even have a work permit yet. They don't understand the asylum process. They're isolated because they don't speak the language. They're culturally dislocated. And they may, if they were released with an ankle bracelet, there's social stigma around that. So even out of detention, conditions are very bad. What's really great about the US, and the reason the US was asked to write the first report on this issue, is because we actually have a pretty interesting and developing infrastructure here of organizations. These are really small grassroots organizations that are doing amazing work with LGBT detainees and former detainees. They're very, very underfunded, they're undersupported, but they're the ones on the front lines helping find LGBT people in detention, figuring out what their needs are, connecting them with attorneys and other services when they're released, trying to find them housing, trying to get them support. And there's sort of this initial sort of infrastructure developing. They face a lot of constraints, including being seriously underfunded, high levels of burnout, right? The fact that these detention centers are far away from where the LGBT resources are located. States that still allow you to discriminate based on LGBT, based on being on your gender identity or even your sexual orientation in some places, et cetera, et cetera. And just to point out this funding issue, I thought this was really interesting, but so the total amount of funding for LGBT issues, domestic funding from foundations, is about a little under 200 million, okay? In terms of LGBT immigrants, they only get 2% of that. And of that 2%, the vast majority, so 4 million out of the 4.6 million, goes to these national organizations that don't do any direct services. Then you have the organizations like these ones that actually do direct services, actually trying to help people. They get only 122,000 total. So it's a drop in the bucket. So one thing is to try to figure out how funding sources can be shifted more to help this population, because right now there's almost nothing out there. All these organizations are operating on a shoestring budget. So I would love to say these organizations should be the basis for a community-based detention program, but how can I really say that when they don't have the capacity to serve these people, even if I said, okay, you guys take the lead, you guys do it. Without the funding, they can't. So I see this as one of the most pressing issues for LGBT immigration equality today. I'll take questions. Yes.
First off, thank you for the lecture discussing such important issues. This is kind of an area of passion for me. I was wondering if you could speak a little bit about the situation of transgender asylum seekers.
Sure.
Who have been convicted of crimes in their home countries.
Great.
Specifically from the asylum laws.
Yeah.
But they've been convicted directly as a result of their gender identity. Say like an ID
Yes.
fraud, conviction, or survival.
Right. That's an excellent question, and that should be added to the list of legal challenges, right? So there are criminal bars to asylum. One is an aggravated felony, and in many cases, if it's a prostitution, or, like we get a lot of clients who've been arrested for prostitution in their home countries, that's not going to trigger the bar, but it still goes to discretion. So I think in arguing those cases, it's really important to try to show how the persecution is related to the conviction. And there are really good reports showing that even in the U.S., trans people are profiled by the police for arrest for certain types of crimes, including sex-related offenses, prostitution-related crimes, and drug crimes. I mean, they're definitely profiled. They're disproportionately arrested for those things. If it's something that actually triggers a bar, then you have a different problem, and then you have to go for withholding or CAT or Convention Against Torture relief, some other type of relief that you can work with the bar. But that doesn't trigger a bar, I mean. Yeah. Other questions? Do you want to make any comments? What do you have?
Actually, I've got a couple notes.
Yeah.
One of the things you were talking about, some of the earlier decisions, why weren't gay and lesbian couples able to adjust their status and become permanent residents earlier based on marriage? And one of the biggest reasons was state law. And that was always the problem, because even if the federal law said it was okay, they had to find some place to get married. So we would have clients who would, from Ohio, who would go to Washington, D.C., or to go to someplace and then they'd come back and then we'd be able to apply for them. Because Ohio, it's a laggard with regards to being able to be somewhat progressive in this category. Any of you guys ever see the TV show 90 Day Fiancé? It's a reality show, pretty well known as being pretty outrageous and stupid. They haven't had, it's basically, there's a K-1 visa, and it requires this person to come to the United States on the K-1 visa, and they have 90 days within which to get married. I'm waiting for them to do a same-sex couple on that. We had a couple of clients who did get fiance visas, and we told them if they wanted to be part of the circus, they could do that, but they didn't take that up. And then another thing I wanted to mention is one of the best ways to overcome that 1-year rule on the asylum is if you transition or come out and then file after that, you can frequently overcome the 1-year rule. That's a great alternative. And that's all I've got.
Yeah. On the K-1, it's interesting that fiancé visa, because only U.S. citizens can apply for that, that means that for LPRs, they're sort of stuck. Let's say you're a U.S. citizen and you're an illegal permanent, let's say you're in the U.S. as a legal permanent resident, and you want to marry somebody who, say, is in China or some other country that doesn't recognize same-sex marriage. If that person can't get a visa to come to the U.S., right, you're kind of stuck because you can't marry them in their country, right? And you can't bring them here under a fiancé visa in order to marry them here. So there's actually still that gap between, like a U.S. citizen could just bring that person here on a fiancé visa and then marry them here, but an LPR can't do that. So they have to figure out some other place they can marry to that their fiancé or their partner can also get to in order to get married. And that can be challenging.
We've had clients actually go to Canada. They meet in Canada, get married, and then they'd be able to take care of things.
Yeah, yeah. So depending on what country they're from, it may or may not be easy to get a tourist visa to any country that allows them to get married.
I want to say one other thing, if I could. The Immigration Service, USCIS, has been one of the more progressive organizations in our government with regards to recognizing LGBT same-sex couples. And I was actually, they're usually a pain in the bottom. But in this instance, I think they've been extremely progressive. As soon as DOMA was struck down, they opened the doors. They sent out notices and regulations. No, not regulations. They don't do that. But memos, faster than any other place. And they were, almost within days of that decision, they were already accepting applications, which was nice. It was good to see.
Yeah, they were ready to go. I think they were ready for the decision, and they had built up to it even before it came down. ICE also, so ICE is Immigration and Customs Enforcement. It's the detention removal arm of immigration. And, you know, they consider themselves very progressive on this issue too, and I do believe they're trying. I mean, so this transgender care directive I mentioned, despite not being implemented anywhere, which is always ICE's problem, is actually quite progressive, like compared to other agencies that detain people. I mean, even just compared to regular jails and prisons. The fact that it even issued something like that is pretty incredible, I think. But, you know, again, you have that big gap between policies that they write that are unenforceable, which all of them are, and actually being able to, you know, if you have a violation of your rights, to be able to get any kind of, you know, any place you can take it, because you can't bring any of those policies to court. They're not legally enforceable. So that's, you know, one of the hooks with ICE. Yes.
I'm just curious, in your experience representing the LGBT community, whether so vital often in an asylum petition is the cooperation of the family, you know, other folks back in the other country, and to the extent that, and I don't mean to generalize, but that LGBT members may not have as good a relationship with those family members, to what extent does that present a challenge for you in advocating, particularly in the asylum context?
Yeah, that's a great point. That is a big challenge, because without that, you know, family members will often testify or at least send letters of support, and they are usually cut off, or in many cases they're cut off from family, and so they don't have any of that sort of corroborating evidence that a family member can provide. And that's a great point. It's also one of the reasons they end up being homeless a lot of the time when they're released from detention, because they don't have family in the U.S. either. Often their family has, you know, forsaken them, and so they don't really have anybody to turn to. They don't have a support network outside of detention either.
Thank you.
Yes.
Hi. I was wondering, how has the landscape for immigration for the Spectrum community changed in the context of the Syrian refugee crisis, if at all?
So you mean, how has it changed here due to like the international?
Yeah, since I'm sure there's a refugee crisis and there are more immigrants from Syria in that area, and I was wondering if that impacted immigration specifically for the Spectrum community.
Yeah, I would say not. I mean, we have very few of the most of those refugees are in Europe. Almost nobody is here in the U.S. We've only taken a very small number. I mean, you know, what is it, a couple thousand out of, you know, millions of displaced from Syria. So we have very few, and I don't think it's had any impact on our asylum population at all, actually. Yeah.
Okay, if there are no more questions, we want to thank Professor Marouf for being willing to come and speak with us today. Lambda would also like to thank American Constitution Society.